So good afternoon, everyone. So, Excellencies, distinguished panelists, friends and colleagues, it's my pleasure to welcome you to IDLO's Partnership Forum. And a very warm welcome to all of you who are joining us online from around the world. I'm Jan Beagle, Director General of the International Development Law Organization, and we organize the forum each year alongside IDLO's annual assembly of the parties to stimulate dialogue on key rule of law issues. And we are again grateful to the Italian Ministry of Foreign Affairs for hosting us here in the Farnesina. This year's edition is special because we are also launching IDLO's new strategic plan, 2025 to 2028, which was adopted by IDLO's Assembly of Parties this morning. And this plan will guide our work at a time when the world is grappling with complex, interrelated challenges, including conflict, climate change, declining trust in institutions, and growing inequalities. As of 2024, only 17% of the targets for the Sustainable Development Goals are on track to be achieved by 2030, while over a third have either stalled or regressed. According to the World Justice Project Rule of Law Index, over 6 billion people, so 76% of the global population, now live in countries where the rule of law has weakened since 2016. With growing polarization, heightened risks, and the possibility of backsliding on decades of hard-won gains on peace, development, and human rights, the next few years are likely to be an extreme resilience test of governance at all levels. In this context, the rule of law can be a powerful tool for promoting peace, unlocking development potential, and protecting human rights for all. Drawing on IDLO's 40 years of experience, partnering with some 100 countries, allow me to share 3 reasons why. First, the rule of law is critical to rebuilding public trust. People-centered justice systems empower people and communities to claim their rights and give them confidence that institutions are working in the interest of all rather than a privileged few. Strengthening governance, promoting transparency, addressing corruption, and ensuring inclusive decision-making can attract investment, generate economic opportunity, and lift people out of poverty. Secondly, the rule of law can help address complex transnational challenges and catalyze progress across the entire 2030 agenda. Effective laws and accessible and accountable institutions are needed to implement all the SDGs, from ending poverty and hunger to advancing climate action and gender equality. The inclusion of women, youth, and other historically excluded groups is essential for the whole of society approaches needed for lasting peace and sustainable development. Working at the nexus of gender, climate, and the rule of law, for instance, can unlock broad development gains. And finally, the rule of law is needed to reinvigorate multilateralism and address complex transnational challenges. The rule of law at the international level, as enshrined in the UN Charter, guarantees the sovereign equality of member states and is the bedrock of the multilateral system. We need rule of law-based solutions to deal with shared concerns like climate change or the regulation of frontier technologies such as artificial intelligence. They require fair and efficient mechanisms that incentivize concerted global action while balancing the needs of the present with the interests of future generations. Our new plan seeks to concretely advance the contribution of the rule of law to peace and sustainable development. From community engagement to high-level policy reform, IDLO will continue to effect change at multiple levels, responding to the unique justice needs and lived realities of our partners. The plan promotes rule of law solutions to expand access to justice, enhance public integrity, reduce the justice gap for women and girls, promote climate justice and inclusive economic growth, and reduce health inequalities. In these turbulent times, we must remember that positive change is both possible and happening. And we will hear today from IDLO's partners who are applying rule of law solutions in their own countries to advance peace and sustainable development. They bring a wealth of experience and expertise, and let me introduce them. On my right, His Excellency, Minister Eduardo IDLO, Attorney General and Minister of Justice of the Republic of the Gambia. Welcome, Minister. And on my left, the Honourable Justice Maria Filomena Singh, Associate Justice of the Supreme Court of the Philippines, and welcome. And also on my left, Magistrate Giovanni Tattilia Pulcini, Legal Advisor at the Ministry of Foreign Affairs and International Cooperation of Italy, and on my far right, Ms. Lillian Adrico, Chief Executive Officer of the Uganda Association of Women Lawyers, or FIDA Uganda. And before turning to our panel, we have received special remarks from the Deputy Secretary General of the United Nations, Her Excellency Amina Mohammed. So let's hear her message.
Excellencies, ladies and gentlemen, it is a pleasure to join you, and thank you to Director General Beagle for the invitation and the Ministry of Foreign Affairs of Italy for hosting us. We gather here united in our commitment to shaping a future that is grounded in justice, in peace and inclusion through the rule of law. In a world marked by interconnected crises, conflicts, climate emergencies, corruption, and the erosion of trust in our institutions, human dignity is under siege. Injustice, inequality, and insecurity continue to threaten the progress we've made, and women and girls in particular are bearing the brunt of these challenges. The question before us is clear. How do we meet this moment? How do we ensure that we do not slide backwards, but instead press forward on the hard-won gains of development and human rights? How do we protect the values of peace and justice for all? The answer is within our grasp. We have the tools. We must now use them with urgency and resolve. Excellencies, friends, the 2030 Agenda for Sustainable Development provides the pathway for our shared future, and at its core lies SDG 16, peace, justice, and strong institutions. As we chart a course toward a more just and sustainable world, the Pact for the Future, adopted by member states at the Summit of the Future in September, challenges us to confront our global crises with bold action. It emphasizes the need for human rights, peace, and justice as foundational elements of our collective progress. At the heart of the 2030 Agenda and the Pact is the rule of law. And it is the rule of law, dear friends, which will see us through these turbulent times. It is critical in addressing systemic injustices, restoring trust in institutions, and creating pathways for prosperity. I commend the International Development Law Organization for its long-standing commitment to the rule of law and its work tailoring solutions to diverse needs and contexts. And congratulations on the adoption of your new strategic plan, which marks a significant step forward in advancing this shared vision of justice and of peace. Let's continue to work together to turn today's challenges into opportunities for a more just, peaceful, and sustainable world where absolutely no one is left behind. Thank you.
Well, I think we all want to thank the Deputy Secretary General, not only for her words, but also for her leadership in this area. And as we face an increasingly complex global landscape, the Pact for the Future, together with the Global Digital Compact and the Declaration on Future Generations, reflect the collective resolve of global leaders to reinvigorate multilateralism and deliver on the transformative ambitions of the 2030 Agenda. And as I said this morning, I believe that this is encouraging and we should build on this progress. So we're going to now turn to our distinguished panel. I'm going to call upon our first speaker, His Excellency Minister IDLO, Attorney General and Minister of Justice of the Republic of the Gambia. He is a strong partner of IDLO who has been spearheading Gambia's efforts to modernize and reform its justice system. And I think, Minister IDLO, since 2019, the Gambia has been enhancing its ability to attract and sustainably manage international investment. And IDLO has been proud to support these efforts in a number of ways, including through our investment support program for least developed countries. So drawing from the lessons that you've learned in the Gambia, how can strengthening the rule of law contribute to promoting enabling environments for inclusive and sustainable economic growth?
Thank you. Thank you very much, DG. I bring you greetings from Banjul. We call ourselves the human rights capital of Africa because we are hosting the African Commission on Human and People's Rights. DG, rule of law in the Gambia, as you all know, we are coming from 22 years of dictatorship in 2017. And our country, during these 22 years, suffered from a lot of destruction. But the judicial sector suffered the greatest brunt. The judiciary, the Ministry of Justice, the securities sector, they were all destroyed during the dictatorship. So as a result, when emerging from that dictatorship, we prioritized rule of law in the Gambia. As a result, we started with a truth-seeking process, which has been completed, and now we are at the implementation stage. We doing the reforms that are necessary to make sure that rule of law comes back to its rightful place. Capacity building trainings, DG, is critical for us at this stage. We've lost a lot of professionals. So building the capacity, which we are proud, IDLO is our very good partner in this area, training for the staff of the Ministry of Justice, training for the judicial officers is critical at this stage, that is capacity building in that area. But also our judicial system is still using a very manual system. And we have a program with the IDLO to try to digitalize the proceedings of the judiciary, the court recording system. This is very critical for us. We have a serious backlog of cases in our judicial system. As a result, this is affecting our growth because commercial cases take ages in the courts, and investors are highly discouraged to have their disputes go to the court. Land matters last 5 years on average. It can go up to 10 years to determine in our courts. So the manual system continues to pose a lot of problem to our development aspirations in the judicial system. So dispute resolution in the courts is still very slow. And the work we are doing with IDLO, piloting the digitalization of the judiciary, will commence very soon. And we have no doubt that it will be successful, and we will roll it out to make sure that judicial dispensation is more transparent, but also is carried out effectively and speedily. This is also important in fighting against corruption, because this manual system are prone also to a lot of kind of corruption. We also have, as part of our justice system, administration of justice in the communities through district tribunals. We have a court system that we call the district tribunals that administer justice in the communities. This is the first port of call for members of the communities when they have disputes in terms of land disputes and other communal disputes. IDLO have identified this with us as a priority area to work on, and already trainings have started for district tribunal members. This capacity building is very important, but the reforms component of it needs to go along with it. So the District Tribunal Act is a 1939 legislation. It requires revision, but that's just an example. A lot of the laws that we are implementing in the Gambia are very old and archaic. They need a lot of reforms. So if I would sum it up, DG, institutional and legislative reform is also a priority in the Gambian rule of law sector. Our laws are very old, but the institutions also need to reform. And for them to reform, their mandates are contained in their legislations. We need to carry out these reforms as well. So Gambia is still in transition. We are 6-7 years into the transition. But for this transition to complete, we need to do a comprehensive reform of our justice sector institutions, the mandates, the laws, and operations, the way we do our day-to-day justice sector delivery mechanisms. So briefly, just to allow other speakers to come in again, and as issues come up, we would share more experiences in this area.
Thank you so much, Minister Jallo. I think you have really set out the stage for us, and thank you for keeping to the time. Our next speaker is Justice Singh, Associate Justice of the Philippine Supreme Court, and in addition to being an eminent jurist, Justice Singh is a leader in judicial education and reform initiatives. And Justice Singh, justice institutions are coming under intense pressure worldwide. And so how can judiciaries adapt and strengthen their resilience in response to the growing challenges to their independence, impartiality, and integrity in order to uphold the rule of law and ensure equal access to justice?
Thank you very much, and good afternoon to everyone. In answer to the question of the Director General, we are at present in a good position because now, after our sad experience about 35 years ago, we have a very strong legal framework. And so the institutions are actually strong and working, and we have a very good judicial system which is in place. But even with that, when you look at the surveys, the public surveys, the trust rating in the courts or in the judiciary are not high, not as high as those for the legislature and the executive. And so we see that as one of the biggest challenges to the court. Even if we have a good rate of disposition, even if the parties perceive the decisions to be equal or fair, but why the low trust rating? And the answer to that, and this was mentioned by the Director General in her opening message, is that the people actually, a lot of them do not understand the processes in the judiciary. The medium of communication in all our court proceedings is English, but practically 70% of court users and litigants are not really conversant in English. So we are addressing that problem now. We are doing more translations. The proceedings, even if the laws or the rules cannot be translated word for word, at least we instruct and train our judges to go out of their way to explain the process before they begin any case to the litigants, especially as a majority of the cases that are pending in our trial courts are criminal cases. And about 70% of those criminal cases, the accused are not capable of hiring their own counsel. And so they rely on the public defenders to represent them. And so it is critical that they are aware of what's going to happen in their cases. And I think that to me will address a great way forward the lack of trust or confidence in the proceeding. But more than that, the country is an archipelago. We have more than 7,100 islands. And so the accessibility, physical accessibility of the court processes and services is really a challenge to us. And that too will go into the lack of confidence in the system, because when they need the judicial relief, it is not readily accessible to them. They have to climb mountains and cross rivers and seas to get to the courthouse. And so transformation through digitization is also very important to us right now. But even if we have those, if the people are not aware of what services are out there that they can avail of, then it will be also for naught. And so that is part of the education and the communication strategy that we are now adopting in the Philippines. And so I think that it's not just having the good laws in place or not having good justices or judges on the bench, but it's really having these people, the institution and the framework, respond to what the people really need. And I think that is what will drive the trust to go up and the confidence to be raised in the judicial system. Thank you.
Thank you very much, Justice Singh. Next, I'm giving the floor to Magistrate Cecilia Pulcini, who's the legal advisor at the Ministry of Foreign Affairs and International Cooperation of Italy, and he is accompanied today by Consigliere Rago, who is the legal advisor to the Minister for Economic and Development Diplomacy, and welcome to you, sir. Magistrate Pulcini, also serves, as I said this morning, to the as Italy's representative to the G7 Anti-Corruption Working Group, which was launched under the Italian presidency this year, as well as the G20 Anti-Corruption Working Group. And IDLO participates in these groups as an observer, and we're grateful to Italy for that, and shares insights there from our programming and research. So, Magistrate, the corruption remains a pervasive issue on the global scale, and it undermines trust in governments and public institutions, and it perpetuates inequality. So how can governments and peoples build on existing legal instruments, such as the United Nations Convention Against Corruption, to promote greater transparency, accountability, and integrity at both national and international levels?
Thank you, Director General, and Your Excellencies. Thank you for giving me the floor. It's both an honor and a privilege to address such a distinguished audience and respond to your question on promoting transparency, accountability, and integrity through the existing instruments like ANCAC. I would like to emphasize the relevance of the recent adoption of a rule of law methodology that reflects both global best practice and collaborative principles. We all know that Chapter 6 of the ANCAC focuses on technical assistance at international level as a tool, a fundamental tool. The G7 approach not only aligns with the objectives of United Nations Convention Against Corruption, but it also serves as a foundational framework to address corruption holistically. An official embodiment of this methodology can be found in the 2024 Italian G7 high-level principles on anti-corruption capacity building. The set of principles is endorsed officially by the G7 communiqué. This initiative reflects international best practices while fostering collaboration. The G7 AHLPs advocate for a robust strategy grounded in 4 interdependent pillars. First, capacity building, which involves enhancing the competencies of institutions and personnel responsible for addressing corruption. Second, institution building, which is aimed at reinforcing public and social institutions so they can effectively support anti-corruption efforts. Third, law building, which focuses on updating and aligning regulatory and legal frameworks with contemporary needs to eliminate systemic gaps. Fourth, last but not least, consensus building, which entails establishing shared values and priorities through inclusive dialogue, ensuring all stakeholders work cohesively to combat corruption. What we would like to promote through this set of principles is a new multi-shareholder approach, which ensures inclusiveness by actively engaging a broad spectrum of participants, including civil society, academia, private sector, youths, media, alongside public institutions. We have an holistic approach, in particular considering the relevance of societal needs. This inclusive approach also strengthens the legitimacy and the effectiveness of initiatives, as it integrates the voices of all stakeholders into both the decision-making and the implementation processes. This inclusiveness is complemented by the co-ownership principle, which ensures that technical assistance and capacity-building initiatives are not merely delivered to partner countries, but are instead developed with their active involvement. Additionally, the methodology underscores inclusiveness and gender equality as cross-cutting imperatives, recognizing that the impacts of corruption often affects marginalized groups disproportionately. The rule of law methodology calls for adaptability. Technical assistance must respond dynamically to evolving challenges. By embedding this methodology in our collective efforts, governments and societies alike can implement ANCAC more effectively and ensure to create a greater, transparent, accountable, and just world with attention to democracy and respect of human rights.
Thank you very much. I'm now turning to Ms. Lillian Adrico, the Chief Executive Officer of the Uganda Association of Women Lawyers. IDLO's collaboration with FIDE Uganda has supported the empowerment of women, including to utilize the law to overcome barriers to justice and improve their livelihoods. So, Ms. Adrico, women and girls often face unique legal and societal barriers that prevent them from accessing justice. And you have, with your organization, an established track record of supporting the legal and financial empowerment of women. Could you tell us what are the main justice challenges faced by women and girls in Uganda, and how is the partnership between FIDE and IDLO helping to create a more inclusive and gender-responsive justice system?
Thank you very much. I'm very honored to be here this afternoon. So one of the major challenges that we face as an organization is that we do not have a national legal aid law. So we rely heavily on donors such as partners such as IDLO to fund legal aid. So we are the primary justice legal aid justice providers as opposed to the state being the primary provider. That coupled with the absence of the witness protection law. We do not have a witness protection law, so this makes the prosecution of cases to their conclusion very difficult. The witnesses are either compromised or they are threatened, abandoning the cases halfway and therefore, leaving us with no solutions or with no tangible results that they come to seek when they come to our offices. The other challenge is the poverty levels. We still grapple with high poverty incidences in our country, and of course this disproportionately affects women. So even where legal aid is heavily subsidized, there are people who cannot afford to come to us to get that legal aid. And then we have the geographic and systemic barriers within the courts of law. My colleagues have mentioned some of them. Sometimes our women have to walk up to 30 kilometers to access a court or to access a police station. So this is in itself a barrier. That coupled with a complex legal systems within the court that in themselves prevent women from accessing justice within the courts of law. We have high illiteracy levels, and coupled with digital divide. Of course, women are less, use the digital platforms less than men. So even where there are innovations within the judiciary that involve technology, women, the uptake of women is quite low. It remains quite low. The other issue is the social and cultural barriers. Women are discouraged from reporting cases. If they do so, they are ostracized from their communities. They are considered an embarrassment to their families and to their communities. So women are discouraged from reporting their cases. We had 12% women that had been violated reporting their cases. This percentage has gone up, but it's one of the barriers that, that persists back home in Uganda. So with partnership with IDLO, it has given us tremendous support. It supports the legal officers to provide legal aid. We do actual court litigation, we do legal awareness sessions, and we also do mobile clinics. So we take services closer to the people with support from IDLO. We've also had IDLO support what we call community justice actors. These are the primary justice providers at community level. These providers have been trained to the extent that where they used to provide about 30%, cater to 30% of the clients that we represent, they are now representing more clients. They are handling and concluding about 52% of the cases that we are handling as an institution. So they've become a primary justice provider within our structures as FIDE Uganda. And my constant advocacy point has been that the support to these community justice actors ought to be increased because they have demonstrated that they are able to do this work even with a little support that they are getting. But this, of course, should be without them losing their voluntary spirit. I need to also add that because they are trained and they're able to provide this legal aid at community level, even where offices close in between projects, it creates a sustainability measure. They are able to continue providing legal aid where we are not. The last thing, second last, is that we've had very interesting and useful collaboration with the International Association of Women Judges. And what we've been doing through these collaborations is basically promoting gender-responsive jurisprudence. We've had moot court competitions where we get students to compete before actual panels of judges. And what these platforms do is they do not only build the capacity of the students that are in that competition, but it's a cross-learning, because what we are trying to do in these conversations is to encourage judges to apply the regional and international instruments as they adjudicate or as they preside over these cases. So those have been very useful platforms. And we've also had open court days where the communities interact with the judges. This is meant to demystify the judiciary, demystify the law. So we have communities ask questions and ask about their case backlog and ensure that the judges respond and make them understand how the judiciary works. The last one is IDLO is very big on building institutions. We are not the same as we were 4 years ago when we became a partner of IDLO. So we are stronger. They've encouraged policy and practice reform within the organization. And through that, we are also able to propagate this knowledge to other like-minded organizations through our leadership academy that the IDLO supported in forming for us as an institution. Thank you very much.
Thank you very much. I'm going to have a second round with the panel. I'm going to continue with you, Lillian, because FIDE Uganda has supported women in securing tenure rights and enhancing their access to financial resources, which is clearly fundamental to drive change. Can you share with us some examples of how legal empowerment and assistance at the community level has helped women to secure these rights and to seek gender parity, for example, in the distribution of matrimonial property? Over to you.
Thank you very much. So as I already mentioned, we have a fairly good legal regime, even in the absence of the two laws that I mentioned. Enforcement of these laws remains an issue. We have a constitution that provides for equal distribution of property at marriage and dissolution of marriage. We have the Succession Act that provides for the distribution of property of a deceased person. But in real life, this is not what happens. The laws are there, but women continue to be affected by various emerging issues within their communities. So what we've done as FIDE Uganda is through the empowerment programs that we have is, first of all, we have a holistic service provision where we also combine legal aid with economic justice. So we empower the women to have agency and to have some money in their pockets beyond the legal aid that they seek from us. Some of these women have gone on to access government programs, but the most important thing is that they're able to buy land in their own names. So in the past, we had women only appearing as witnesses. They did not know. They would appear as witnesses on purchase agreements, even where they have contributed money. So now they are aware. So they know that they're supposed to appear as co-purchasers. We have women registering land in their own titles, in their own names, titles in their own names. So they are owning titles and they are therefore bankable. They're able to go to the banks and secure loans because they now have collateral to present in the banking institutions. We also have those that are not able to negotiate for themselves to appear on these titles. We've drafted for them user right agreements. So for women who are tilling the land, for example, we have agreements with their husbands, with their partners that prevent the husbands from chasing them off the land at harvest time, and also that prevents them from taking the proceeds of the land. That's what used to happen in the past. But now we have agreements that manage these, these processes. The other is that we've also sought legal redress. We have a strategic interest litigation case in court, and what we are doing through this case is to challenge the state, because the state only recognizes relationships that are legally recognized. So for relationships like cohabitation, if you accumulate property within a cohabiting, and I'm talking about monogamous cohabiting relationships, it's difficult for you to lay claim on that property because it is not legally recognized. So we filed a case in court to challenge the status quo, and I believe that if we have a pronouncement on this, it will speak to a couple of women that we represent in the organization that are in similar circumstances. About 80% of our women are in these sorts of relationships that are not recognized by the law. Thank you.
Thank you very much. I'm now turning to Magister Pulcini. So we've talked about the rapid development of technology. And can you tell us how can leveraging digital technologies help reduce the potential for corrupt practices in particular?
Thank you also for this interesting question. The Italian experience provides a robust model for making use of digital technologies to address corrupt practices like corruption in public procurement. A cornerstone of our strategy is the National Database of Public Contracts, a centralized digital platform which standardizes and integrates data across the entire public procurement life cycle. Is a database managed by our National Anti-Corruption Authority, which is an independent one. Recent reforms under Italy's new public procurement code have reinforced this digital transformation. Italy's collaboration at the European level further enhances this framework through initiatives like the e-forms and the public procurement data space. Our national agency promotes standardization and interoperability, enabling cross-border comparisons to benchmark value for money and detect corruption's risks. A particularly impactful innovation is the implementation of a red flag system which identifies context prone to corruption. I would like to underline this red flag system because it's really a model at international level. Our efforts demonstrate that digitalization is more than a simple tool. It is a transformative strategy for combating corruption, for preventing corruption. Transparency, innovation, and accountability work hand in hand, ensuring, in particular to procurement systems, to deliver integrity and an added value for all.
Thank you very much. Now, Justice Singh, we've talked this morning a lot about climate change, and in the Philippines, IDLO has partnered with national stakeholders to conduct a gender assessment of climate and environmental laws, and the findings which we published last month on our website, I think, provide a crucial resource to advance climate justice for women and girls. So why is legal equality for women and girls essential for accelerating climate action, and which areas do we most need to prioritize?
Thank you very much, Director General. Actually, the statistics is that for any type of natural disaster or even man-made disasters involving the environment, 70% of those mainly affected are women and girls. So they are the principal victims in these types of circumstances. And they get separated from their communities, they are uprooted, they get separated and cut off from their schools and from their families and from their sources of livelihood. And that is the main reason why, Director General, we need to always insert the gender issue when we talk about environment initiatives. In the Philippines, we're actually at present reviewing our rules of procedure in environmental cases. We are very proud of our rules of procedure because I think we were the first ever to institutionalize the concept of legal standing for generations yet unborn through the decision in Oposa. And of course, we also have a writ of continuing mandamus under our rules of procedure. But that one we are restudying because we issued that in the 80s, in the early 90s for the cleanup of the Manila Bay. But until now, that writ of continuing mandamus is still in force. And so what has happened is that reports of the executive bodies and agencies who are tasked to do the cleanup are given to the Supreme Court. So that is not really within our sphere anymore. And so we have to give more details to the process, where after a certain period of time, that is turned over to the executive for continuous monitoring and reporting. And then, of course, the concept of damages. And this is something that the IDLO can really help us with, especially with the study that they gave, which provided us with so much details and recommendations. In the Philippines, a violation of an environmental law is treated like an ordinary civil case or an ordinary criminal case. Let me give a concrete example, illegal logging, for example. So what the judge will do is just check if was there illegal logging and who were caught with the products of or the fruits of the crime. They are penalized either by imprisonment or fine, and that's it. Nothing is said about what damage was done to the environment, to the forest, and what should be done to rehabilitate it. And so at present, we have what we call a green zone or a green justice zone in Palawan that is an essential or a critical area in the country where a lot of the coral reefs in the region are located. And in that green zone, we are developing what we call the Green Book. This is a multi-sectoral handbook for all the justice sector actors, from the law enforcement, the investigators, and then up to the prosecutors, the judges, and then the community. The community we are mobilizing, they are now our reporting and monitoring agents in the green zone, and we are all training them because one of the challenges also is that those who are involved in the prosecution, both the law enforcers and the prosecutors, are not as familiar with the environmental laws and the implications. And so they would rather file normal or regular criminal cases like theft or robbery, for example, for the trafficking of endangered species, because they do not understand the environmental laws that govern those actions. And so capacity building, Director General, is really very important here. And that is why we are developing this green book. We want them to know how to handle these cases. And for example, for our judges, what to include in their decisions so that they do not miss any of these important things. And an important chapter in that green book is, of course, the gender aspect of it. What do you do when these things happen, when there are these violations and the women and the girls are affected? What can you do for them? So a partner also in this, in the preparation of this green book and in the trainings will be our Department of Social Welfare and Development, because they are the ones equipped and tasked with providing the necessary psychosocial aid for these types of circumstances. Thank you.
Thank you very much, Justice Singh. And Minister Jallo, so as you have said, the Gambia has already launched several very forward-looking reform processes to strengthen the effectiveness and efficiency of the justice sector, and we're pleased to have supported you with this, and particularly the launch this month of a new court reporting system. Can you tell us why reforming the justice sector is a priority for the Gambia, and how the timely dispensation of justice can help to increase people's trust in government?
The reform is a priority for us because no society can prosper without rule of law, without an effective rule of law system. Is a given. So it is the dispute resolution mechanisms, and disputes are normal in our human endeavors. When they occur, we all run to the courts. So to having an effective rule of law mechanisms in every society, I think is a sine qua non. It's a given, it's necessary, and we cannot do without. Effective judicial system and speedy dispensation of cases in the courts, it's important for us to build public trust. I can tell you for now, we're even piloting an alternative dispute resolution system in the Gambia. And recently I received statistics. Quite a lot of people are approaching the dispute resolution secretariat for issues that are not even suitable for alternative dispute resolution. Why? Because they don't like going to the court anymore, because they think when they go to court, they'll spend the rest of their lives in pursuing simple disputes. So as a result, some of them mistaken, because not every every matter is suitable for alternative dispute resolution, but because they just don't want to go to court and they want to have their disputes resolved, so they would wrongly go to the wrong forum, that is the Dispute Resolution Secretariat. So to bring back that public confidence, DG, it's very important court matters are dispensed speedily, of course, speed not at the expense of justice itself, but speedy dispensation of justice, particularly for the commercial disputes, is very critical. The banks are already complaining in the Gambia. Things like mortgages, to foreclose a mortgage and for a bank to recover its debt can take years in the Gambia because of our longhand way of recording proceedings, and also because we do not have specialized courts to deal with this kind of thing. So for us, digitization is critical, and we can't wait to see the launch of this pilot phase and also eventual rolling out to the rest of the courts. But we will go beyond that. We would also encourage the establishment of specialized courts like we have children's court, of course, but we do not have a specialized automated commercial court. This will go a long way in bringing back investor confidence into the judicial sector. But overall, it is critical for us to win back the confidence of our court users to start with this digitalization.
Thank you very much, Minister. Going now to open the floor for a few minutes for anyone who would like to pose maybe a question or a comment, a brief one, to our panelists. So I'm going to see if there is anyone here in the room who would like to make a comment or ask a question. Yes. The representative of Senegal, please.
Merci beaucoup.
Thank you. Thank you very much, Director General. First of all, my congratulations with the speakers for the high quality of their contributions. They have come from abroad to tell us about their situation. Two elements I would like to tackle. The rule of law, relevant rules and regulations that must be incorporated in our own framework. I'm not talking about the literal translation, because often a translation is a betrayal of the original text, but very often local language doesn't really reflect some of the concepts, and sometimes the legal texts are very difficult to translate. Some legal terms are difficult even for me, even though I am an expert in the legal issues, so it's difficult to translate in my own language some part of the terminology. It is really difficult. This is something that affects not just the courts. So during trial, I often don't understand, meaning I'm in a hearing, but I'm not hearing. It's a pun. So it means that we must encourage and support the transposition of the legal terminology in the local language, and a good agreement is better than a bad trial. So today we're facing a crisis between those that seek justice and those that handle and manage the legal system. Some cases are insupportably long, the costs are unbearable, and people cannot afford a trial. People don't understand how the whole justice system, legal system work. People don't understand very often. Talking to the people, I find it hard to make them understand the difference between a lawyer, an advisor, a counsellor, and a judge. Some people have lost their cases because they didn't have a good counsellor. So lots of people think that it's a counsellor that really makes the success, that guarantees the success of the case, which is not it. What you really need is to know exactly what the role of the judges and are, and the other point is that the backlog of cases that affects many courts. So some cases might be handled in other courts and thus reducing this backlog. Some cases might be dealt with maybe at the local police force headquarters, maybe just inviting the people involved. One might reach an agreement. There are many different ways to try and reduce this backlog that many courts are affected.
Is that the case?
Oh, can you?
Hello?
Hello?
Please go ahead.
Yeah, can you hear me?
Yes, please
Yeah.
go ahead.
So thank you for giving the time to me. I am Wajifa Timuri. I'm a managing partner at Iki Wajifa Law Firm based in Afghanistan. So it's the first female lawyer led in Afghanistan. I have the question, which is basically for IDLO and based on its mission and mandate, that in light of IDLO's mandate to promote the rule of law and access to justice globally, what specific strategies and programs does IDLO plan to implement in Afghanistan to strengthen legal institutions, uphold the rule of law, and enhance equitable access to justice, particularly in fostering the rule of law within the legal profession? So it's my main question.
Thank you very much. And we also have online Nimat Payman. Hello? Do we have Nimat online?
She's just dropped off online.
Okay, so it seems maybe he's dropped off for the moment. I'd like to call on anyone else who would like to say something in the room. Yes, sir, I cannot see your name plate. Could you?
Thank you.
Who is it? I can't see.
Okay. Thank you, Madam Director General. It's Blaise Kwemlangan from the Legal Office of FAO, and I bring greetings on behalf of Donata, the Legal Counsel, as well as our colleagues from FAO. I just wanted to offer a comment and a suggestion, maybe come question, and this is in relation to the good talk. Well, first of all, to say thank you to the August panelists. I think they have provided a lot of fodder for our discussions on this very important topic. Congratulations also to IDLO for having adopted your strategic plan, and to say that indeed SDG 16 is a particular goal with its own targets, but I think it also, SDG 16 also serves the other SDGs in terms of rule of law and ensuring that the targets for all the other SDGs, the 17 or so, 21 or so SDGs that have to be, the targets that have to be achieved will also need support from SDG 16. So if IDLO places itself in that capacity to lead the work on SDG 16, this is most welcome. Now, my comment is in relation to crimes, especially those that the two judges, I think, have mentioned in relation to environmental crimes. And the fact that this is still an ongoing battle, especially in relation to Justice Singh's comment on the fact that the judges and judicial officers really sometimes need a lot of capacity building as well, especially in the areas where they are not experts in, because you don't have specific training on environmental issues, on fisheries, on forestry issues, and therefore the issue of capacity building is quite important. And there are some initiatives that we are taking to work with judges in certain areas, in particular in the seeds in small island developing states. But there's still a lot more effort that needs to be done in the area of capacity building training for judges and judicial officers, such that they will be able to address and give the kind of importance to addressing those cases when they come before them, instead of listing them further down on the list. And then also to say something in relation to the fact that in addition to the UN Convention on corruption, there is also the United Nations Convention on Transnational Organized Crime. And in that area, we're still struggling to make environmental crimes to come to the same level as those other crimes. And only because there is the issue of the criteria, where, the threshold that has to be met in relation to then treating those crimes as transnational organized crime. And I'm referring in particular to the custodial sentence of 4 years, I think it is, in order to treat it as a transnational organized crime. So if it's below the threshold, then you cannot treat those crimes as transnational organized crime. And in particular in fisheries in certain areas like the exclusive economic zone, Article 73 of the Law of the Sea Convention says you cannot impose custodial sentences unless there is an agreement between two states, and that the law actually provides such sentences to be imposed. And therefore, this is a matter, I think the UN has said that this matter needs to be addressed, and I'm hoping that IDLO for sure, and at least the experts around the room, can be able to make their views known also to this high-level task force that is just convened by the Bureau of the Executive Bureau of Entities of the UN, that they will be able to ensure that certain things like this, both in relation to capacity building as well as this remaining issue of ensuring that environmental crimes meet certain threshold, could be addressed. So I thank you very much again.
I thank you very much, and this morning I did thank the Director General of FAO for our cooperation across the board in legal affairs and also security and others, so thank you so much. I want to give the floor now to the representative of the United States.
Thank you, Director General Beagle and distinguished panelists. I'll be very brief with my question, but you did talk a little bit about the importance of other stakeholders, that this is a multi-stakeholder effort. So can you talk a little bit about stakeholders outside of the legal sphere? I'm thinking tech companies, educators, health professionals, that contribute to strengthening the justice system. What has been your experience in bringing in these additional partners and stakeholders?
Thank you so much. I'm going to have, I think, two last speakers before I give the floor back to the panel for some concluding reflections and to answer whichever questions they would like to answer. And the next speaker is the representative of Burkina Faso. You have the floor, sir.
OK. Merci, Madame la Directrice Générale. Je voudrais revenir sur l'intervention de l'Ouganda.
Yes, going back to what the Uganda representative said about the legal aid system in Burkina Faso, we adopted a legal aid system back in 2016 to give help to those that seek help, that need the justice system but have no financial means for doing so, because we know that access to justice in Burkina Faso is extremely costly and expensive if compared to the population financial possibility. In Burkina Faso, it is the state that funds this legal aid fund. And I would like to avail myself of this opportunity to highlight how the authorities are, how thankful they are to IDLO for the help that IDLO provides, so that, because it makes it possible for the most vulnerable groups of the population, for example, women, can actually have access to the justice system. I have a question to Ms. Arico. In our country, this legal aid fund, as I said, is financed by the state. And if I'm right, in Uganda, apparently you said that it's the private sector that funds this legal aid system. I would like you to tell us a bit more about this system, a bit more in detail. If you can tell us, how is it possible for the private sector to take part, financially take part in this system, in this fund? Because maybe there could be a public-private cooperation that could be interesting in our country too. Thank you.
Thank you very much. I do have one more speaker in the room and one online, so I'm going to take those. It's a representative of Niger.
Merci, Madame la Directrice Générale.
Thank you, Director General, ladies and gentlemen. I'm grateful to be able to speak on behalf of Niger to once again state how important the IDLO role is, especially in my country. Your caravans have made it possible to get in contact with tens of thousands of people, to educate them, to make them aware of crucial topics such as gender-related violence and youth education. Thanks to this, you've been able to give new hope to our communities, local communities. Back to the Senegal ambassador said in his proposal concerning the translation in local languages, I'd like to say that is important too, and thank you for all your support. And thanks to that, we have quicker legal proceedings, so that prolonged custodial sentences have avoided, and people have been more able to get access to justice and the justice system, so that fair justice, it becomes an instrument for the development of the country. So in the name of Niger and Africa, I would like to thank you for your commitment and your support that will make it possible for the world to be more fair and more inclusive. Thank you.
Thank you so much. We have one more speaker online, Ms. Marissa Boswam.
Hi, good afternoon to all. I don't know if you are hearing me properly.
Yes, I'm hearing you.
Thank you so much. I was addressing a question in the very practical small steps that the speakers foreseen as the next stage, because seeing myself as a lawyer for more than 20 years, the transformation of justice, and seeing how far we are still from the goals, what would be the best optimal practice to start the digitalization process in countries that have less resources, like in the Global South?
Thank you so much. Well, I'm now turning back to our panel. I'm going to start this time with Justice Singh. Some final reflections and answering any of the questions that you would like.
Yes. Thank you very much, Director General. I'd like to address the comment of our esteemed representative from the FAO about the training, the capacity building that's needed. Actually, you said something really, really important. Judges are not trained on the technical or the scientific side of it. In a lot of our environmental cases, the evidence received are technical and scientific. And so we really lack that, and that is what we're doing now, even keeping up with technological advancements. Like in most other climate litigation, satellite imagery is already accepted as evidence, but in our country, our rules of evidence still does not allow that. And so we have to adjust that in our country, aside from doing capacity building. On legal aid, I want to say that in our country, we have what we call the mandatory legal aid service. We impose the duty on all members of the Philippine Bar to render free legal aid 60 hours in a cycle of 3 years. So every 3 years, they have to render different types. It can be as simple as preparing a contract or an affidavit for a litigant. And it can also it can also amount to preparation of briefs or other pleadings for courts. And that has boosted the opportunity for our court users who are unassisted by counsel because they do not have the capacity, because really the lawyers' fees are the main reason why, you know, access to justice is really an issue in our country. And aside from that, we have what we call the clinical legal education program, which has made mandatory the establishment of clinical legal aids in all our law schools across the country. And the law students who practice are supervised by members of the bar. And so that also has widened or broadened the field of available free legal aid service givers. But I think the most important that I want to discuss is we have created what we call the online free legal aid directory, which is accessible online anywhere in the country. Anybody who needs free legal aid will just look at that directory. It is arranged by localities. So wherever you are, all the free legal aid providers are there, and there's a description of what type of legal services they can give you. And we have what we call the mandatory referral system, where the first provider approached cannot render the service, must look for another provider in the area who will be able to render the service for the person in need. So, and then as a parting statement, DG, the last question asked of us online is, what do you think we should do for those of us who have very little resources? We started out that way, coming from that difficult period in our history, and no one wanted to deal with us. The confidence, the trust was really low, but we always told our people in the judiciary, the only resource that we really have is ourselves, and so let's work. We started working with what we had, and when people started seeing the results, they started coming to us and talking to us. What else do you need? We want to help you because we can see that you are really passionate about what you are doing. And so now we are at this position where we have done a lot of good things because of partners like the IDLO. And so I think you just work with what you have at the present, and then once you have some results, the people will see it, and then they will find that you are worth investing in. Thank you.
Thank you very much. I think you are right. Success builds on success. I'm turning now to Magistrate Pulcini.
Thank you again, Director General. I try to merge some questions and concentrate my attention on only few of them. First, trying to merge the first point from the Senegal representative and also the FAO General Director. I try to respond with the new methodology of is expanding all around the world, this legal diplomacy On one hand, concentrating the attention on the need of harmonization of rules, but it is not only a technical harmonization. It is a new modality to see the rule of law, and these, for the Senegal question, has consequences, positive consequences on the language, to allow to all the people to understand with the co-ownership what it's happening to the rules. And coming to the representative from the FAO, I totally agree with you, considering the 16 SDG as a cross-cutting one, and also in seeing what is the threat of criminality nowadays all around the world. And let me try to respond on the legal diplomacy first directory, which is build a new harmonization of law, but also a common knowledge of what is happening all around the world. And what we are called to ensure is a more effective cooperation and coordination among judicial authorities all around the world. We have to work on this. We have to ensure also the informal judicial cooperation to ensure response and answers to the new threats. And coming to the last question I want to address from the US representative on the so-called multi-stakeholder approach. We are trying to change our approach to the involvement, effective involvement of civil society, private sector, academia, and media in our processes. And it's the first time we have adopted in a common official language at the G7 level a new definition. We call it multi-shareholder approach, to underline that we are not speaking to counterparts, which is exactly reflected in the multi-stakeholder definition, but we want to underline this new philosophy, and it reflects an experience from Italy in a nutshell. We have an interinstitutional table which involves public sector and private sector to address and to select all the preventive possible action in the fight against corruption. It is not only an Italian experience, now is endorsed by the OECD as a good practice and by the ANCAC second cycle review report, which called it a best practice, an inter-institutional and intersectorial mechanism which allow to private sector and civil society to officially participate to the prevention of corruption.
Thank you so much. I'm turning now to Ms. Adrico.
Okay, thank you very much. I'll just quickly clarify. Legal aid service provision is now the primary role of NGOs in Uganda, not the private sector. I hope I did not make a mistake on that. But interestingly, FIDA is making 50 years this year, and one of our campaigns is to get the private sector on board so that they can be, we can have local philanthropists to support some of our legal aid initiatives. No success story to tell yet, but I'm optimistic that when we next meet, I can share something around that. It will be something that will be profiling as we approach the celebratory dinner on the 7th of December. On the question of the multi-sectoral approach, I do agree with you. We have done some work with educators. We actually have IDLO-funded feeder clubs in schools, and these are rights clubs, and what we do in those clubs is basically to teach children their rights and responsibilities. So we've started at that level, but we also have started conversations with the academia to do critical research on topics such as male engagement so that we can have a uniform approach to male engagement and male allyship. I hope to report on that after that research is completed. So we do have that in the pipeline. There's an ongoing effort, and it's something that we hope to report on in the subsequent reports to IDLO. Parting shot for me is as happy to read in the strategic plan an outcome on economic justice and inclusivity. I think that is critical to the conversations that we are having, and it's also in a way a sustainability measure. We note as FIDA Uganda that women that are economically empowered are less susceptible to domestic violence. So to include that as an outcome speaks to a good plan ahead for us as legal aid service providers. And also the other thing that I saw, which is I think is still an elephant in the room, is the perils of technology, artificial intelligence and its different manifestations. We see an emerging issue on technologically generated gender-based violence. And we have cases that have been reported to us as an institution, but we have a problem with investigating and prosecuting these cases because we simply do not have the capacity as yet. So your recommendation to partner with tech companies, I suppose, will help us to decipher some of the complexities around TGBV and the various manifestations. Thank you very much for listening to me this afternoon. Again, I'm very honored to be here. Thank you very much.
Thank you very much. And last but not least, Minister Jallow.
Thank you. On sustainability, for me in the Gambia, thinking of integrating, especially the IDLO interventions areas, after the piloting and the rollout, to integrate them into our national programs for the purpose of sustainability. I admire the Philippines approach, and I'm sure if we integrate it and we work hard on it, assistance will always come. So for me, integration is key into the national programs for sustainability. On legal aid, we are very similar with what is happening in Philippines. We even have a legislation on Legal Aid Act, and we have a specialized institution on legal aid called the National Agency for Legal Aid. For us, if somebody is being prosecuted for capital offenses, and by this, if you face an incarceration of 10 years and above towards life imprisonment, and you cannot afford legal representation, is by law the state have to provide legal representation at the expense of the state. So for us, it's statutory in the Gambia. But also, we've just recently amended our Legal Practitioners Act. I didn't know that it's happening in Philippines. I could have understudied you because I hear some novelties there that we probably will copy to improve. But we've already on the verge of amending our Legal Practitioners Act also to make it mandatory for legal practitioners to take on board pro bono legal aid services to the public, and they're required to spend a number of hours of this. For us, it's annual, that they need to fulfill before their practicing certificates or licenses are renewed for the subsequent year. They need to prove that they have rendered some service to the public. But I see legal aid also even within the interventions of IDLO. This, the combination of sensitization and legal service delivery in mobile clinics is a form of legal aid, because legal aid is not only representation in courts, but when you educate somebody beforehand and empower the person with required legal knowledge, is a form of legal aid because you are giving the person the basic legal skills that he or she needs to either avoid a conflict or manage a conflict, a legal conflict, I mean. So for me, all these things can be seen as a form of legal aid in terms of carrying out sensitizations. So IDLO, you are also doing legal aid in your interventions through these mobile legal clinics. So pretty much, I think those are the areas that I picked to summarize my final intervention. I thank DG and the IDLO for all that you are doing in the Gambia and all that we plan to do in subsequent years. And I congratulate you for a very well-organized state parties meeting that you held this morning. We are proud of you. Thank you for inviting us to participate in this forum.
Well, thank you so much, Minister, and thank you to all the members of this really wonderful panel. Thank you to all of you who have joined us today in person and all of you who have joined us online. We really appreciate your participation and support. I think we've had a very rich discussion. We will all have our own takeaways from it. I'm not going to summarize it in full, but I maybe give you the major takeaways that I've taken from these last what I consider very rich discussion. And maybe starting with what the Minister said, no society can prosper without a functioning rule of law system, and I think that that is fundamental to what we are trying to do with the work that we do at IDLO. We're really trying to collaborate with our partners to find those areas that can really make the difference in terms of having a functioning rule of law system that is accessible and responsive. And I think we've heard about the importance of having strong and comprehensive and updated legislative frameworks, but frameworks that are really relevant to people's lives. So this requires, obviously, good capacity in the justice institutions at all levels. And I think that what we are seeing is that we need to do that capacity building at all levels. It's clearly, it can be police, it can be lawyers, it can be legal aid, it can be prosecutors, it can be judges, but also we've heard it can also be social welfare workers, or it can be immigration people. It can be lots of different parts of the system. They all need to have capacity, and they particularly need to have capacity in new issues which are upcoming, and we've heard about environmental crimes and others. This is an evolving situation. There are new issues coming up all the time. And that in putting together these legislative frameworks, we've got to focus on the needs of the people, and particularly the most vulnerable people. So if the institutions, however good they are not accessible, and we heard about different kinds of inaccessibility, if you like, from Minister Diallo, people who are unable to understand, and as the representative of Senegal said, I mean, people who do not have the laws in their own language, or as Justice Singh said, people who have to cross mountains or seas in order to access a court, or as Ms. Rodrigo talked about, the digital divide that many people face. So how to make them accessible? Clearly, we talked about education, we talked about communication. All of that is empowerment, and all of that leads to trust. And I think we've heard from all of our panelists about the importance of building trust. I think quite a lot of discussion about digitization. I was very interested in what Magistrate Puccini said about digitalization being a transformative strategy, and I think that all of us would agree with that, but we've also got to remember the digital divide. We have to make sure we don't create new forms of inequalities, but that clearly digitalization is so important in so many ways, but particularly I think for transparency and how it can really open up systems, increase trust, but also support anti-corruption efforts and other such efforts. I think it's really important that we look at ways in which we can focus on inclusive economic growth, what has been said about integration of justice systems into national development priorities, particularly for sustainability. So we've got to look at anti-poverty strategies and inclusive economic growth strategies. We've heard from everyone, I think, a particular focus on women and girls. Clearly, the laws on the books are not always the laws on the streets, and we know that, and it's especially true for women and girls and other vulnerable groups in many societies, and we know there are cultural barriers. We also know that climate change is not gender neutral, and I think it's encouraging to hear the different strategies which are out there, including the male engagement. I think that is extremely important. We've heard about the importance of, I think, multi-sectoral approaches, or actually, as Major Portuni said, multi-share. I like that. So it's not just governments, although governments are fundamental, so yeah, but also civil society, the private sector, youth, media, I think judiciaries, academia, international organizations, of course. So whole of society partnerships, as we say. And I think the importance of sharing experiences is very important, and we've heard of a number of good experiences today. Can be South-South experiences, can be other experiences like the red flag system shared by Italy. So there are lots of ways, I think, to share this experience. And maybe finally, I think, as FAO reminded us, the importance of SDG 16, it's central, I mean, in terms of accelerating implementation across the entire 2030 agenda, and certainly IDLO will continue to keep the rule of law high on international agendas and to work with our partners to advance practical solutions to help them tackle their challenges. We're starting on a new strategic cycle. I invite all of you to read our new strategic plan, which has been launched today. We believe it's not just a roadmap for the next 4 years, it's really a call to action in the pursuit of a world where every person can live in dignity and equality under the law. And I really would like to, again, urge all of our partners, particularly our development partners, but actually all our partners, to continue to invest in the rule of law as an essential element leading towards peaceful and inclusive societies. And we believe that reinforcing the rule of law is central to achieving the 2030 agenda, and I would say also the Pact for the Future, which is the most recent multilateral instrument adopted. So let me thank all of you for joining us. Let me thank all of you for continuing on this journey with us. And I'm about to close, but before I close, I would like to let you know that there will be coffee available before you leave. So thanks to everybody in the room and online. Thank you for coming, and thank you for continuing to work with us in this really, really important endeavor. Thank you, and bye-bye.